My name is Wade Poziomka, and I'm a partner at Ross McBride in the Human Rights and Employment Group. Today I want to talk to you about pregnancy and parental leaves in the workplace. Can an employer terminate an employee for becoming pregnant or refuse to allow an employee to return to work following a pregnancy leave and parental leave? As a human rights lawyer, I deal with pregnancy reprisal cases frequently. Sometimes employers are upset at the business inconvenience caused by the pregnancy leave. Other times they simply prefer the employee who was brought in on a temporary replacement. The Ontario Human Rights Code protects employees from discrimination in the area of employment. One ground of discrimination that's protected is sex, which includes pregnancy. Let's start from the very beginning of the employment relationship, the job interview. Employers in Ontario are not permitted to ask employees questions about pregnancy, including future intentions. Are you pregnant? Do you plan on having a family? Are some examples of inappropriate questions. They may permit an unscrupulous employer to refuse to hire an individual on the basis of a pregnancy or upcoming pregnancy, without the employee ever knowing that's the reason. The next question I'm often asked by employees is, I'm pregnant, do I need to disclose that to the company I'm interviewing with? And the answer to that is no, and there's good reason for that. Some employers would simply pass the candidate over knowing there would be a leave to deal with in the near future. It's acceptable for employees to disclose their pregnancy after being hired and closer to their due date. Sometimes employers see this as unethical and sneaky, but again, there are very good reasons for not disclosing. What about employers who get upset at the length of time an employee is going to take for a parental leave or pregnancy leave? The length of the leave is up to the employee, as long as it's within the range permitted in the leave provisions of the Employment Standards Act in Ontario. Employers pressuring employees to take a shorter leave or expressing displeasure at the length of the leave within the protected period is unacceptable and a violation of the ESA and the Human Rights Code. Another common question I'm asked, this time by employers, is do I have to return the employee following their leave? They'll point to one of two things typically. First, mistakes found after a replacement came in they didn't know about beforehand. Or two, they like the replacement better in terms of productivity and they don't want to lose them. Failing to return an employee to her position following a pregnancy and parental leave is discrimination and a breach of the ESA leave provisions. It doesn't matter that you prefer the replacement or they're a better worker. You can, of course, keep the replacement employee as well as the returning employee, but you should not give away any of the returning employee's job duties. You also shouldn't look to terminate the returning employee at some point in the future when it won't be so close to the time they took their leave and therefore apparent. The Ministry of Labour and the Human Rights Tribunal of Ontario are both live to this possibility, and a future termination will be carefully scrutinized. It's important to remember that child rearing is a societal good. Women should not be disadvantaged because they are or have been pregnant. Rather than see these leaves as a burden, employers should think about how to make the workplace inclusive, designing policies to support individuals who take leaves of absence. One example frequently implemented is an EI top-up for parents on parental leave. When you find out you're pregnant, there's a lot to navigate. There's employment insurance, reprisal protections, when to tell your employer, what if you change your mind about the date that you want to return. Should you have any questions or need any assistance, feel free to reach out.